We're back from recess. Mananasi Zulus colleagues. Clerk, could you please take the roll to determine whether we have a quorum? Our session was called for 9:30.
Senator Barnett. Senator Blas. Senator Brown. Senator Dueñas. Senator Fisher. Senator Lujan. Vice Speaker Munya Barnes. Senator Parkinson. Senator Perez. Senator Kanata. Senator San Augustine. Senator Siniclis. Senator Shelton. Senator Taitagui. Speaker Terlahi. Madam Speaker, there is no quorum.
There is no quorum, so we will remain in recess until at least one more member shows up. But thank you to those who are here this morning. And thank you to the AG's office who is here since 9:30 or earlier. Thank you. Recess. Just reporting that it's 10:10. We're still waiting for a quorum. Apparently, there are 8 senators in and out of the session hall, but not continuously in the session hall. We need 8 to continue. We have 7 right now. So we're just going to remain on recess till we have 8 so that we can resume where we left off yesterday with Senator Parkinson's questioning. All right, it's 10:20. We're back from recess. We finally have a quorum. Thank you, senators, for being here this morning. I'm just going to have the clerk please call the roll.
Senator Barnett. Senator Blas. Senator Brown. Senator Dueñas. Senator Fisher. Senator Lujan. Vice Speaker Muñoz-Barnes. Senator Parkinson. Senator Perez. Senator Canata. Senator San Augustine. Senator San Nicolas. Senator Shelton. Senator Taitigui. Speaker Terlahi. Madam Speaker, there is a quorum.
Tijusmasi clerks. All right, we're going to continue where we left off. We are in Committee of the Whole to go through 2 rounds of questions for the AGs. The senators have 5 minutes on each round for questions, unless time is other senators' time is waived to them. Thank you again to the Attorney General's office for being here this morning. We left off with Senator Parkinson. You still had more time on your turn.
Would you say that a government employee cooperating with the Attorney General is acting in good faith when they follow your legal advice?
Good morning, Senator Parkinson. I'm not going to answer your line of questioning. They're relevant to 2 ongoing criminal cases before Judge Tolentino and Judge Terlahi. As I said earlier, it would not be appropriate for me to be making arguments or giving testimony that probably is going to end up in the Superior Court.
I'm not asking about any specific case here. I'm just asking as a general principle, if a client, a government agency, follows the advice of the Attorney General, would you say they were acting in good faith?
The Assistant Attorney Generals that give advice to not the client, the government official is not the client like I pointed out yesterday. The government official acting as a steward and having a fiduciary duty to the government of Guam, the people of Guam, if that Attorney General gives advice, it is considered to be presumptively legal advice that is in compliance with the law. If they give the wrong legal advice, then the Attorney General will have to review it on the circumstances regarding it. As I said, my assistant AGs under my administration do not give illegal advice that breaks our laws. And if they do, the Attorney General will be reviewing it.
So I got a question then. With GRTA, did Tom Keeler not give them advice that it was okay to hire Rich Ibanez?
I, with respect, Senator Parkinson, will not answer the question because it's dealing with an ongoing litigation before our criminal courts.
But I mean, this kind of strikes to the heart of this legislation, right? Is somebody that cooperates with the Attorney General acting in good faith?
Respectfully, Senator Parkinson, I will not engage in that line of questioning.
I just want to read a relevant section. 30108, Defense of Judges, Officers, and Employees. Whenever any action for damages is instituted against any officer or employee of the government of Guam in his individual capacity for the performance of an authorized official act, the officer or employee may request the Attorney General to undertake the defense of such action. If the Attorney General finds that the officer or employee acted in good faith, then subject to the approval of the governor, he shall appear and defend the officer or employee. These people are following your legal advice, and then you are prosecuting them for it.
I will go further to add to your recitation of Guam law under 3108B, nor to prohibit the Attorney General to decline the defense of any of the above officers or employees on the grounds that the criminal prosecution or disciplinary action requiring the action by the Attorney General may proceed from the acts which are also the subject of civil action for damages therein referred. The legislature's passed already anticipated.
And so why didn't you set up a conflict wall? No, why didn't you set up a conflict wall? Why didn't you set up?
Please allow him to finish the answer, and then
I'm yielding back my time. Why didn't you finish the conflict wall? Why didn't you establish a conflict wall, sir?
As I said, I will not talk on any specific case.
That's not about a specific case. Why didn't you just do any conflict wall? That seems like a pretty standard practice.
In general, it is not, because Section 3104 and 3109 do not require any Attorney General to construct a conflict wall when they're executing their duties to prosecute public officials for the people of Guam, Senator Parkinson, and provide legal advice to those government officials who are not the client. The government officials are a steward like you are for the people, like I am for the people. That is the perspective in which these statutes must be reviewed. So, you know, we're going in a circle right now. I'm not going to talk about existing court cases. I've already said that the legislatures passed since 1975 have created a scheme consistent with other states of the United States, including the federal government, that the Attorney General has dual duties, dual hats, and you are not the Attorney General's client. The government official is not the Attorney General's client. They are a representative of the Attorney General's client, which Congress has stated is the government of Guam. No person in this government is the government of Guam. They are representatives. They hold a fiduciary duty to the people of Guam.
Sir, you have abdicated your duty, and you should be ashamed. I yield the rest of my time.
Respectfully, Senator, that is your opinion. I
Thank
disagree.
you. Thank you, Senator. Senator Duenas.
Madam Chair, and thank you to General Moreland and the team for being here. I'll go directly into a quick statement and then ask some questions. General Moreland, as you are aware, I called for this to take place for two reasons. One is we were debating a bill that's currently in the third reading file that contemplated removing you after 5 days, having not taken action on that bill. Thankfully, that amendment is set aside. I want to recap the fact that you have made the statement on the record yesterday that you're perfectly willing, capable, and going to execute this legislation should we pass it and honor the 5 days at least to meet the review requirement, as well as any findings that you may have to clarify with the procurement that GPA is putting forward in order to satisfy this, the spirit and letter of this law should it be passed into law.
You have my personal commitment as the Attorney General of Guam that my office, including Mr. Botha, who's made his statements under oath, will have these documents reviewed under these emergency procurement documents reviewed under the auspices of an emergency declaration and need to have these things processed out of the AG's office within the time frame that the legislature requires. 5 days is fine.
Your office will not be an impediment to this procurement?
To the extent that we are a check and balance in the system, if there is an irregularity in the documents, my understanding of review is to make sure that they follow the legal form, are not violating Guam law, and follow the legislature's mandate.
Which would be the normal course of your review, whether it was an emergency or a general procurement?
That's correct.
General Moreland, I also wanted to make sure the team was here because I'm very concerned. The dialogue, as far as I'm concerned, between the state of the territory addressed by the governor and the anxiety that exists now within our community in terms of legal review, I believe needs to be addressed, and that's another reason why I wanted this to take place. I am aware that you've sent a letter to us recognizing and asking us to consider legislation, but I wanted to start from the beginning. You mentioned yesterday, and I want this to be clear on the record, that you have given the governor an avenue in your findings of having to make sure that you're not conflicted prior to this current impasse. Can you explain that?
I'm sorry, you indicated I'm not convicted? What was the...
No, you had given the governor a avenue to address what you're trying to ensure that will eliminate any possible conflicts, and why you address this issue with the governor's office and the procurement and the 21 agencies that you listed, that they're, because of ongoing investigations, you need this clarity to ensure that your review and your operations of, making sure that you carry out your duties against government corruption are clear on both sides and you avoid the conflict. Is that correct?
That is correct. The situation that was created because of the prosecution of management officials that are held to these departments has created a situation, and we wish to operate in the AG's office ethically. There is a question about this scheme that was set up by the legislature in 1975 that are not addressed by the Supreme Court's 2003 Model Rules of Professional Conduct. So in order to act ethically, we withdrew temporarily, gave notice to these officials within the government. Governor, then we had a workaround, which was basically just understand that there's a disclosure that we're not representing you personally, which I believe reflects what Guam law is. And then had a meeting with the governor. Governor seemed to not want to acknowledge the disclosure, so we're just going to approve these documents, review the documents, and then stamp it and then sign off on it.
I'm sure the media will cover this, and I want this to be clear that the impasse is such that it seems as though the governor has made a decision to not agree with your workaround, which would prevent any of this scenario of these procurements being held up, and they could go forward with the option that you've given the governor.
I believe that the governor's declaration of an emergency was unnecessary. I sat down with the governor, explained to the governor and her council the situation. I believe that, and the governor's not an attorney, and I'll give her that discussion on that. But we as attorneys, that's the whole focus of the AG's office, to be attorneys, to provide legal representation, believe that there is a hole that needs to be clarified by the courts. So there is no problem. We are processing any documents that need to be processed, returning documents that do not fulfill the legal requirements to have it corrected, and then processing it like we did last month, 2 months ago, and like we've always done.
So you're currently reviewing and doing your fiduciary responsibility of all procurements that come to the Attorney General's office, and you will continue that work. That is your duty and responsibility, but you will also continue to say that you need this workaround in order to basically commensurate the contracts as they come to you. Otherwise, we would need to pass legislation to address the concerns.
That is correct. The governor's statement that I'm not fulfilling my Organic Act duties is incorrect. We're fulfilling our ethical duties, and we're fulfilling the Organic Act duties and doing everything we can to protect the people.
General, I would say it's some great importance with the programs that have been put on the record in terms of their potential jeopardy, that the people of Guam understand completely that our highest level government officials are engaging and would forego any anxiety or any loss of federal funds or programs that are effectively to be delivered to our people because of our leadership not being able to sit down and come to a conclusion that you've presented options, opportunities in order to be able to handle these situations. I think people of Guam need to hear that.
Not processing contracts and procurements that are in the best interest of our people of Guam is not an option for the Attorney General's office.
General, I will basically give you my last question so that people can understand fully once again the proposed amendment that you've sent to us in order to address this issue. And I will make it clear on the record, because I know there's been legal concerns that have been brought forward by the legal community, which I completely respect and admire, because all officers in the court should be engaged in this issue. But I want to be clear once again that should we move on this, and you've never asked us to act and move without a public hearing, I think it would be prudent to move to a public hearing so that you can defend your arguments and arguments can be brought forward. But in the interim, since you're here, since we can understand the other option that you've given besides the workaround, please once again thoroughly discuss the presentation that you've given to us in order to be able to enact this in law and clear this up once and for all.
Thank you, Senator Duenas. This draft that we sent over to the legislature was in response to what the governor was characterizing as an emergency. We do not believe that it was an emergency, that the workarounds could have gotten around the situation without having to call the legislature into session, but respecting the fact that the legislature is concerned, rightfully so, about the situation. We drafted a legislation, but at this time, I don't think it's necessary. I think that because of Senator Shelton's bill, the Speaker, Senator Barnett, and who I've been speaking with, there are sufficient bills before the legislature to just deal with the procurement of the generators, which I believe was the purpose of this special session. I want to reiterate again that I believe that our court system should be allowed to continue in its adjudication of these important ethical concerns. I did not think that we needed an emergency session or any bill required for it. So as you can see, the second part of the bill was dealing with the procurement. That's been incorporated into Senator Shelton's and the current bill, I think it's 240. That's on the agenda right now. 254, excuse me. That's on the agenda right now. The others, again, we're not trying to change what is existing in Guam law. We believe that in 1975, the legislature already set the rules for the Attorney General, be the prosecutor, and also provide legal advice to the government's stewards, which is all of us. So to create the attorney-client relationship will create a problem for the Attorney General doing the legislative mandate. And other AGs are in the same situation. The federal government, federal United States attorneys is in that situation also. So I respectfully thank you for your question. I think what the senators, what you are dealing with right now will resolve the issue without even having to address this proposed bill that we kind of drafted up.
So you realize, General, basically with the pending nature of the legislation that's before us, I believe we're still acting responsibly by trying to pass this emergency measure, just to add an extra layer of confidence that the legislature has acted, you have committed to this review, and that we can all move forward, because I believe none of us wants to stand in the way of possibly being able to alleviate load shedding and hardship to our people.
Exactly. And on the particulars, the policy, whether this is a proper procurement and so forth, that is within your discretion. I understand you're going to be discussing it with GPA directly. We will be reviewing it for legal form and complying with the statute and the watchdog function of the Attorney General's office to ensure that people's interests, legal interests, are being protected. Thank you.
So I guess I just want to clear one more thing up. There's been a mention that the issue is over whether or not in individual capacities, attorneys, either yourself or within the General's office, are attempting to provide a shield for themselves in terms of what they do, whereas what I've heard you in action of their duties, otherwise what I've heard from you is what you are doing is ensuring that the law is clear in terms of how you're acting, whether or not you are prosecuting government corruption or you are doing civil work to review contracts for the continuation of procurement and other items that will be passed to your office that the government of Guam has in its mandate for your approval.
Correct. We are operating within the congressional mandate as an Organic Act officer. We are operating within the legislative mandate by the local statutes passed in 1975, and we are acting within the Supreme Court of Guam's regulation of we lawyers. All three are trying to be reconciled right now through the courts, and we're just trying to do our job.
My concern, General Moy, and I want to see if you concur, I'm a little bit uneasy about the fact that court matters should be handled in the courts. If there are legal arguments, fight them out in the courts. I hope that we are simply passing legislation to assist going forward, but I look forward to public hearings where others can opine and comment on it. But do you share my concern?
I share your concern, and that's why one of my statements to Senator Parkinson on his bill was that it was undemocratic. It was a midnight massacre. They were wiping out the Attorney General through an unvetted public hearing bill. And I believe his, I don't have the bill number in front of me, but what I've seen introduced by Senator Parkinson was taking away the will of the people for an elected Attorney General to protect their interests and creating 3 Attorney Generals, one of which was a government corruption appointed by the governor, which is going back 20 years to what we did as a people, making the Attorney General directly accountable to the people of Guam, not the governor of Guam. So, yeah, public hearings are very important, and especially with affecting the duties of the Attorney General's office and ripping away that right to elect an Attorney General from the people. It's election interference.
Madam Chair, I know my time is up, but I want to make it clear that I put this on the record. I take no position on what the legal matter is. I take a position that our duty is to pass law that can pass muster as per the Organic Act and the Constitution, and the ability for us and our government to operate as a tripart government within their own capacities. So I want to be clear, I'm not taking a side here. I'm merely saying that I am uncomfortable and will remain uncomfortable debating issues that appear, if there's a difference, should be resolved as conflict in the courts. Thank you, Madam Chair.
Thank you, Senator. Senator Blas, and then we'll go to Senator Brown.
Thank you, Madam Speaker, and to the panel, thank you very much for being here. I know it gets kind of boring, especially when we don't ask you questions. Okay? General Moylan, and I guess I know you've repeated this time and time again, and I just just to make sure that it's clear, with respect to Bill 206-37, okay, and that's where my focus is going to remain on. The 5 days once you receive the documents for your review, It is your testimony that your 5 days is more than sufficient time to be able to make those necessary reviews and provide it back to GPA?
Good morning, Senator Blas. Yes, that is our testimony, and I have the deputy that has direct responsibility for that is also put on the record. We will get it out within 5 days or
Okay.
probably sooner.
Okay. The question needs to be asked, okay? What are the consequences if it doesn't come out within 5 days?
Well, that's the same type of situation we face every day. You've got the commitment. This is a focused committee of the whole meeting on it, and we will get it out within 5 days. The consequences, you know, it's like slapping the hand and saying, do it, do it, do it, underlining it. Is that how we run the government? That's not how we run our AG's office. We work closely with the legislature to make sure that your laws are enforced. And as the Chief Law Enforcement Officer, it would be a black mark on me as an attorney not to live up to my commitment and to follow the law.
Okay.
Very clear, 5 days, it's got to get out.
Okay. Actually, that's just all the questions I have. I wanted to keep specific to the bill so that we can move this bill along. Thank you for your testimony. I hope so that we don't have to endure the load shedding. Thank you very much. Thank you, Madam Speaker.
Thank you, Senator Blas. Senator Brown.
Thank you very much, Madam Speaker, certainly, and thank you to the Attorney General and your team here for patiently waiting for us this morning to show up. I just want to follow up, because certainly I know my colleagues have already asked the question, but there was a representation by the Guam Power Authority that somehow your office was uncooperative in responding to them, and I assume that's the reason they've chosen this legislative route to bring this legislation forth, that you can see there were some members of this body that obviously are willing to remove you from your duties. I think the landscape's very clear with regards to that, and this process here with this emergency session has very much brought that to light. So I just wanted to, again, allow you the opportunity to reiterate your position, because that's the representation that's been made to us. I see the GPA Council also provided an extensive letter to our legal counsel. I don't know why. I don't know the purpose of this particular letter, other than it's a bit irritating, because I don't feel the need moves along the issue that GPA has desired here. But I want to get your feedback on that for the record officially, Attorney General Moylan.
Good morning, Senator Brown, and thank you for your comments. I know that you are a strong advocate of good government and ensuring that our taxpayer dollars are spent appropriately. I have our expert in this area, and especially on the utilities, Deputy Graham Botha, that has consulted with me during all these procurements with the Guam Power Authority. I've seen the correspondences going from the Guam Power Authority to Mr. Botha and Mr. Botha's responses. They tried to get us to waive a procurement authorization that was going through BJ Cruz's public auditor. We refused to do so. It would have been the first time the AG would take away a check and balance in the system. Mr. Botha advised me that this is not in the best interest of the people of Guam to be waiving procurement appeals, because there's a purpose for the appeal in order to ensure that the taxpayers and the ratepayers are getting reliable power at an affordable cost. So if they're griping about that type of issue, I'm sorry, that is the duty of the Attorney General's office, is to ensure the laws are being properly effectuated, are being enforced, that we are the watchdog for the taxpayers and your laws that you pass. And Mr. Botha has been instrumental in communicating, and we have been communicating. Their attorney, who used to be an attorney with our office, Marianne Wolichuk, has communications with Mr. Botha. And I've observed them and seen them. So it's within the discretion of the Attorney General to waive a part of the procurement appeal process. We discussed it and chose not to do that. We're talking millions of dollars, and affordable power is part of getting power. If you can't afford that power, it's going to hurt the lower class, middle class consumers that are already being hurt by the inflation we're experiencing. So, you know, it's part of protecting the public interest, and we commit to you that anything that you pass today will be followed by our office. I presume they're constitutional, and of course the Attorney General always has to look at things in terms of the bigger picture and statutes, but everything I've seen today is fully within your discretion to do. The fact that the legislature is once again looking at an emergency procurement, which means that other possible bidders to provide the ratepayers a lower cost of power, better services, and so forth, are being obviated, and that's the first red flag that comes up. Is this really in the best interest of power, or is there a back deal door that's been done with a particular vendor? And I've already been indicated by Mr. Botha that there might be, but we've been communicating with certain senators here to possibly bring that up to GPA, important questions that must be asked. That's not my job here at this point. So whatever comes to us, we will look at for legality and following the laws you pass.
Well, and I think as expected, I mean, we have to ensure that that check and balance is in place. And I think you've unfortunately gotten a very unfair presentation here from some of our colleagues, because I don't know what their agenda is. But I also believe that there's a need, and certainly a need that's been there for a very, very long time. I'm sure you're finding out in the course of your work. You know, what we used to think was the exception is pretty standard in terms of abuse in this government and corruption in this government, that, you know, we say we serve our people, but a lot of people are profiting instead of ensuring that that money's going to the interest of our public. You did commit also that you would facilitate reviewing this particular bill, and I'm not too crazy at all about the timelines. I mean, they originally provide you 48 hours to do so, and I think the expectation is unreasonable, and we understand GPA's concern. And we also understand, and it's been thrown around, that if, as the main sponsor told us a few months ago, that if we didn't pass this bill, that we would be responsible for load shedding. So I guess now that hat's been transferred to you, that if you don't properly review this legislation, you're responsible for load shedding, even though at the end of the day, that responsibility falls squarely on the shoulders of the Guam Power Authority. So I think it's important that we relay that, and you've already made your commitment that you will properly review this bill in the timeline that's been provided, so the process can move forward with regards to the acquisition of additional power reserves. But, you know, even though initially our colleagues yesterday, the delay that happened, I guess, was the back and forth debate as to whether or not we should have you on the floor, and if we should, perhaps we should have other parties here to counter whatever you say or do. And at least a number of reasonable minds here decided that we didn't want to see a circus, and we simply wanted the elected Attorney General to properly respond to the questions that we have here in the legislature concerning the legislation before us. And yes, I concur. I mean, this particular bill, the second bill that's been provided by Senator Shelton, should go to public hearing so that it would allow the opportunity for you and anyone else in the general public who wants to testify to do so, and then we can take that information and determine how to proceed. You have a tough job, Mr. Attorney General. You have a lot of people working against you, a lot of people that have vested interest in protecting their interests that you don't. They certainly don't want you or anyone else digging in their backyard, but I'm sure you will do what you have to do. I think we have an expectation of that.
Follow the money, Senator.
Follow the
private
money,
attorneys,
yes.
The financial incentive for my detractors must always be questioned. Are they getting paid by a party that is not the people of Guam? And should they be in that position to be speaking to you, senators, without disclosing that fact? We have Attorney Ariola's contract that we've indicated. He has a contract with the Guam Airport Authority. He's one of the individuals that wanted to speak out on this. Those things have to be asked. How much are you getting paid by the governor's Guam Airport Authority? So, you know, I'm sorry, that's just, when you do white-collar crime, when you do testimony before the legislature, conflicts of interest should always be put on the table first, so that the people of Guam can evaluate the merit and the genuine arguments that are being made or not being made, because you're getting paid on the side. That's the whole white-collar crime investigation. And Senator, you know that 22 of these government departments and agencies came from, many of them, the public auditor. We provided in the documents. It's not about Doug Moylan or this particular Attorney General. It's about protecting the people's interest. And when you've got another elected official accountable to the public that's saying that there's red flags, it's the money. It's the amount of money that the taxpayers are having to pay that they shouldn't pay, and the corruption in the government. That's the type of allegations, the investigations. Thank you, Senator.
Well, and we understand that, and I certainly hope, you know, Attorney General Moylan, that you continue and your team continues to do what you're doing. I know you're up against a big challenge, but you're right. There's a lot of money, a lot of power, and a lot of vested interest, and including members of this body. There's connections to the front office as well, and benefits that they receive that they don't publicly announce every time they speak to support the administration. How unfortunate, because we run to say that we're here to serve the people of Guam, but really sometimes we're serving our own interests, and there are people that are benefiting from the fact that our government is not running the way it should. So I appreciate your time, the time of your team, and as I mentioned, in spite of the detractors, including some that are here, I think you'll find there are a lot of people out in this community that want you and expect you to do the job that you're doing. there's a need for it. I mean, we see the crimes at all levels in this community. I think we agree it's unacceptable, and there has to be a counter to that. There has to be consequence for abusing the people's trust. And so continued success to you in your work, and we're certainly, those of us that are here to support you will continue to do so. Thank you for your time. Thank you very much, Madam Speaker.
Thank you.
Thank you, Senator Brown. Senator Perez.
Thank you, Madam Speaker. Good morning to Attorney General and the Attorney General's office. So a lot of the questions were asked, and for me, you know, my focus has been primarily about procurement and how do we streamline procurement. And of course, we are in the situation where procurement is, there's definitely an impediment at this point. And I guess my question is going to basically revolve around resolution of the conflict of interest question, as well as, you know, how do we move forward and how do we, you know, build back better, so to speak. So in regards to resolving the conflict of interest question, so what are is there a declaratory judgment that needs to be done, or how do we proceed to expedite the resolution of this question?
Thank you, and good morning, Senator Perez. I am not an advocate at this point of changing anything that's going on in the judiciary right now. When we issued our February 28th and February 29th correspondences to 22 departments and agencies that were under investigation, civil and criminal investigation by the Public Auditor AG's office, this was intended to ensure that we operate ethically in the AG's office. The procurement system is still going to work. We had the workarounds for it. It wasn't necessary to be necessarily changing anything that was already existing. And as an attorney, it would be better to not create an ethical conflict than to create one, or to continue in one when it's under judicial review. So the procurement process right now has been working. The GPA is attempting to use the emergency procurement process, which has nothing to do with the AG's office. We're going to process it out quickly. We have, I think, upwards of 100 contracts that are on 30-day type of reviews by the AG's office, and will continue to be under review. If a contract has a illegality or some problem with it, it's our job as the public watchdog, the check and balance in the system, to send it back to the government official. The situation that we have in the courts, though, is that when a act of a government official, especially the management officials, become prosecutable and should be prosecuted, which, by the way, the grand juries are the ones that are bringing these cases to the court system. AG cannot just file a case without the grand jury being involved for the felonies, or on a misdemeanor would be the judge that would have to review the probable cause. That criminal justice system is intended to, I guess, enforce Guam law, to provide the penalties associated with Guam law. And these management officials are trying to use that position that they're holding as management officials as a shield, saying that, oh, you can't prosecute us because you gave legal advice. When a document comes over to us, our primary job is to protect the government of Guam. That is our client. So Senator Parkinson's line of questioning, if you look carefully at it, was trying to coax the government official as the client. And again, the Congress says that that is not our client. So everything that's on the table right now, we're looking very carefully at. We're looking at our ethical obligations. We're looking at your mandate to us, including the 1975 and what you're considering right now. And just make the system work properly to the benefit of the public. We don't want to delay anything. That's our whole purpose. That's why before I came in, there was no 30-day requirement that contracts be issued out of the AG's office. Mr. Botha will testify that there is, for several months now, if not 6 months or more, a 30-day requirement that contracts that come in must be processed out in some form, either signature or sent back to the department with the anomaly that needs to be corrected. But we can't have government officials saying that you can't prosecute us because we are your client. That's just going to wipe out one half of the statutes passed by the legislature. Thank you.
Thank you. Yeah, so I think there definitely is a need to address, I mean, obviously something's lacking in the system to kind of prevent this, I guess, a conflict of interest. Should it be adjudicated as such? You know, how do we move forward and, you know, in a expeditious fashion, but correct fashion as well? So I think you're mentioning back when you were AG in the past, there was a corruption division.
Correct.
What extent was the AG's office involved in procurement at that time?
Same thing. Nobody ever raised this type of concern because it's common knowledge the AG has the prosecution hat as well as the provide legal services hat. So this is not necessarily a novel argument, but I mean, you go to DC, they're making the same type of arguments, and I heard from one of our attorneys here in Oklahoma, the same situations being occurred where a criminal defendant is trying to say that AG can't prosecute them because they are their attorney. So the courts have cases that they can look to, and our Supreme Court of Guam, as I mentioned, with the Brooks case, the airport decision, and most recently the Barrett Anderson versus Camacho case, they are acknowledging the unique role of the Attorney General and the common law powers of an Attorney General. We are not a private law firm. There's no way you can put us close to a private law firm because private law firms don't enforce Guam law. They don't have the people of Guam as their client, and they don't prosecute putting people in jail. They just give legal advice to their client. So how can we move this faster? I do not recommend anything other than just to rely upon, have faith in our judiciary. I have faith in our judiciary. And it'll be worked out.
Okay.
These are just temporary measures.
So yeah, I know you did submit a proposed legislation. And so with this, I mean, maybe if you can talk us through the different parts of this bill?
Well, it's a bill that I actually, it was only prepared for purposes of this proceeding. We did not introduce it, and we don't necessarily want it introduced, given what I've seen to date. The second part of it, Section 2, deals with what Senator Shelton's bill is dealing with, and the first part was essentially a recitation of what the Guam law already is, but that's why I say the courts already have it in front of them. We're not trying to change what we believe already exists in the law. The 1970 law addresses the ethical question. If you take the private attorney's perspective, this is what Senator Parkinson's Bill 257-37 is trying to do, rip the AG's office apart. That is not the scheme that is currently in effect. I've never seen any jurisdiction, any state, do what Senator Parkinson's trying to do, have 3 attorney generals, and to have the government corruption people be directly under the control of the governor. That speaks volumes about the intent of this bill. It's to stop the corruption investigations. Why would a governor want to appoint any attorney general that's investigating her cabinet? That's why they passed the 1999 amendment to the law and made it a congressional statute. So the legislature can't remove the attorney general. Same thing with the public auditor. The public auditor was put into the Organic Act so that that watchdog couldn't be removed by fiat of a legislature and a governor.
Okay, thank you. So the other thing is 5150, right? So I guess it was my understanding that the SAGs were higher classified employees, but in practice it wasn't. It was mostly contracted?
Yeah, they were private law firms. You see the danger of what the prior AG had done? You took away the ability, forfeited the ability to a private law firm that would take payment and orders directly from the government official. They do not recognize, and they have no prosecution authority either. That's why having a assistant attorney general designated would have that authority. You're relinquishing control of the assistant AGs or the SAGs under the former AG. This one, we revoked all of them for the watchdog function because you want the SAG to fulfill the duties of the AG. We've appointed SAGs, what are they called? They're called special assistant AGs, but they're under the direct authority of either the chief prosecutor or the attorney general ultimately. So unlike the prior, my understanding of the way the prior AG had been administering that program. So, but they're not conflict counsels, they're SAGs.
Okay, so but I guess the way it was implemented was, you know, basically the law basically can allow for in-house SAGs versus contracted SAGs, or I'm mixing the two.
It's the same nature. The contracts go directly with the AG's office. In the other ones, the contracts may have gone directly with the department that they were being relinquished to. That's my understanding.
Yeah, because again, I'm trying to the reason for the questioning is how can we strengthen procurement, right? So if we can maybe identify a pool of procurement counsel and,
Thank you, Senator.
segregate that, yeah.
Very good question. The problem, again, you have is, do you want the people's elected watchdog looking over these procurements? Like I mentioned earlier, 16, 20 years ago, I never had a, and you're addressing mainly the agencies, I believe, with these 500,000 and the 500,000 requirement that the AG's office look over that. AG's office doesn't look over any earlier, any procurements that are less than that. So that means that those agencies can continue to do their procurement under 500,000. Some legislature between the last time I served and now decided that the AG's office was necessary to watchdog those agencies, because agencies have more independence than the departments do. And the airport decision in 2005 said that the AG's office is subject to however the legislature prescribes the power. And the scheme of senatorial statutes since then has been to give the autonomous agencies the ability to hire private counsels. This was a fight that we had back 16 years ago, sort of thing, 2005 era. So my understanding is you want these procurements to be legal, to not have any sweetheart deals on the side, to not have any corruption in them. Hence, you put the Attorney General involved, because when he sits there, he's not going to allow it, in his role as the prosecutor and as the enforcer of your statutes and the people's rights. So by increasing the number from 500,000 to 1 million, you've got procurements less than 1 million that could have shenanigans going on in them. That's what I see. If you keep it at 500,000, that's the current scheme that everybody is operating under. And I'll just do a little bit of reflection. If you really want to stop the corruption in the autonomous agencies, don't let them hire private counsels. Give the money to the Attorney General's office so that we will hire salaried employees under the people's watchdog, the elected Attorney General. That is the most effective way you're going to stop corruption in the autonomous agencies. The Airport Authority, the Port Authority of Guam, GITA, you look at the billings, and BJ Cruz has spoken out over this over the years, and I've seen the media articles. He criticizes what I was doing 20 years ago. You lose control of proper government spending when you let people hire their own lawyers. They're not accountable to the people. They're accountable to the person who's paying their salary, which is the autonomous agency. You just name it. There's a whole list of problems that have occurred in those those agencies. If you had an Attorney General, the risk of corruption would be less.
So generally, I guess it turns to capacity within your office. You definitely need more
We are hiring weekly. Lawyers are coming in now. I said we were going to do it, and we're doing it. We have recruiting all through the states right now. Several people on this table in front of us have been on Guam less than three months. We are satisfying the needs of our public. And I want to thank the judiciary because they've been processing. They increased the temporary licenses from 5 years now to 8 years because it is an island-wide problem. We don't have enough private lawyers and government lawyers. And I have a good team behind me. We're hiring the lawyers that we need to protect and enforce your laws.
Okay. I guess the other thing too, I guess the conflict of interest still is overhanging all of this. You know, no matter how many attorneys you still have this conflict of interest that can affect the whole organization. Is that correct?
It could, but you know, the conflict walls that we were discussing here, the cases talk about them and how they're applied to the Attorney General's office. That's why I have faith in the court system that they will work this out. There's a plethora of cases out there that talk about the unique role of the Attorney General. Judge Manabusan, in the decision I cite in the 28th letter, I quoted exactly what he stated. You don't see protecting the public interest language and phrases on private lawyers. That is only unique to public attorneys, the Attorney General, District Attorney, Public Defender. Well, the Public Defender is a different side, but the District Attorneys in the states and the Attorney Generals, their mandate is to protect the public interest and essentially protect the people. That's what it means.
Okay, and I know you mentioned there was a booklet you showed us. It basically has the rules of
professional conduct.
Professional conduct.
Like
right?
Accountants, I don't know if doctors have it, but they operate under ethical rules. Yeah, actually, they do have it. The attorneys operate on what they call the Guam Rules of Professional Conduct. Again, it was passed in 2003 because the Supreme Court now has the Organic Act authority to regulate attorneys and so forth. but it has no reference, in most part, to the Attorney General's office. It makes a statement. I think prosecutors must act in the interest of justice. I think there may be a rule on that in there. But there's no comment about how the main rule is imputed disqualification and conflict of interest as it applies to the public Attorney General, that law firm, the biggest law firm among Guam, because it's for the people, paid for by the people.
So is it due for more changes then to address this?
Our team has been discussing the possibility of either going forward with the two cases that are raising these issues and are becoming ripe for the Supreme Court of Guam's discussion, or just independently, because this isn't just pertaining to the two cases, petitioning the Supreme Court to engage a committee to look at all the cases in the U.S. that are being cited in court and update our Guam rules of professional conduct. That is, we're clearly looking at that. We just don't want to, upset everything that's going on right now. So.
And looking at other AGs in other jurisdictions, do they have the same issue with procurement? Like if there's a conflict of interest, does it affect their procurement scheme, or do they have different procurement schemes?
This issue occurs in, I think, most every AG's office. It depends on the statutory scheme, how they set it up. As I mentioned, the federal model, U.S. attorney, but that's appointed by the president, but still, they deal with prosecution and civil advice. So, and they have one law firm, that the Merrick Garland doesn't get disqualified or set into two different law firms in order to handle civil and criminal prosecution. As I mentioned, the state of Oklahoma is currently, I understand, going through the same conflict of interest because they're prosecuting high-end management government officials that are under their governor. So you've got that conflict being raised in the criminal proceedings there, I understand. Is this question coming up in other jurisdictions? It's not unique to Guam, clearly not unique to Guam. But the Guam model is a bit different because there's only the smaller states that have the Attorney General that is both the public prosecutor and the civil attorney providing legal advice. Bigger states, they break it into counties with district attorneys. You still have an Attorney General. Some of them have different mixes. The Attorney General can maybe handle certain cases that the district attorney conflicts out of, and then that Attorney General would handle that prosecution or handles the appeals. It just depends on which state we're looking at. That's why the Guam Supreme Court will have many states to look at as this case goes up, as do the two Superior Court judges dealing with this right now. The arguments are currently being made.
Okay. Thank you for the responses. Appreciate it. Thank you, Madam Speaker.
Thank you, Senator Perez.
Speaker Terlai, you're recognized.
This is Mossy. Again, thank you to the panel for being here and answering our questions. As you know, I called us into emergency session partly on the issue of the Attorney General's withdrawal of representation from some of the agencies. There was a list of 21 at the time, now 22, where the AG says they are under investigation based in part on OPA audits and some on independent investigation. And so I was concerned immediately with several things. One was we have contracts pending that are over $500,000 that by statute must be signed by the Attorney General. Second, we have agencies that have very technical issues before them. For example, the Chamorro Land Trust Commission, who I do not believe can proceed in some matters without legal advice. They are interpreting laws, they are interpreting rules, and they need advice. And right now they're represented by the AG, and with the withdrawal of representation to them, I wanted to make sure that they are not going to be held, all their actions held in abeyance, when it's really been complicated for them when the shift over of attorneys recently. Third, of course, there are some long-term issues that are concerning, but not the subject of this emergency session. Those are, if the pending cases before the Superior Court find some conflict or that our statutes create a conflict that cannot be removed, then of course the legislature must address those somehow. But but immediately, so the situation has evolved. And at least one of our concerns is allayed, that is the signing of the contracts over $500,000. So you assured us yesterday that despite the letters where you said you might say potential conflict cannot sign, now that has evolved to you have a way of signing those contracts. You will say approved, not representing any public official, and you will be able to review and sign contracts over $500,000.
Yes.
Of course, the judicial rules are not within our control, and the case, we will just wait. I understand one of those cases was, we're pending a decision since November, and so hope we'll see that soon. And but still, I think what we have before us, and I want to flesh out today, is these agencies without counsel, perhaps, right?
Departments.
Departments and agencies where they've been told you cannot represent them while they're under investigation at this time, pending the decision from the court. All right, so what do you propose for those agencies?
We already had it, reviewed it at the AG's office. Ethically, if I cannot provide the representation because of these questions of the ethical rules, I need to make sure that they have some form of legal representation, somebody to give them some advice. Not necessarily to sign off on contracts that the governor might get, sort of thing, because I think the watchdog function, obviously this is a different category we're talking about when we sign off on those documents. But we have an understanding at the AG's office that depending if the governor wishes to inform her cabinet or the board members that she has appointed to seek counsel, we would approve the temporary retention of their separate attorney for that department. Obviously, a person is under criminal investigation, they need to get a private attorney in order to answer those type of questions. But the attorney that the commission, like the Criminal Land Trust Commission, may need because they're under investigation is a contract would be generated, go through our office, we would make sure that it is a temporary contract for them, and we would approve it. And I think that's inherent in an ethical responsibility. If your client's steward can't get that representation, that they have it.
All right, so for those agencies where they are allowed to hire a lawyer, they're going to be able to do that, who are currently represented by the AG, they will be allowed to do that, subject to the AG's resuming of representation. What about, do you believe, well, there's a statute that says if they did that, if for hiring lawyers, dentists, physicians, some other people, that the governmental body of Guam may act as purchasing agency and contract on its own behalf for such services subject to regulations, but shall not authorize the procuring of such services when any governmental body is otherwise prohibited from procuring such services. And those are the contracts that the AG signs off on. Well, at least, no, I'm sorry, only the legal services contracts the AG signs off on. And you're stating before us right now that you have no issue continuing to sign off on contracts for those agencies to hire lawyers where you have declined representation of those agencies.
That is correct. For the temporary period, if the legislature has given us a role in that department or agency, we will, and we need to temporarily withdraw, we will approve those replacement counsels.
So do you believe that those agencies are allowed to do that without us, the legislature, giving them that type of authority where we have currently restricted them from hiring and must go through the AG's office? Or
I'm thinking it would be prudent to put in a bill that type language, yes.
All right, so that's what I'm looking at. The governor suggested some language. I suggested some language, but this sentence that they proposed was, if the office of the AG withdraws from representation of a governmental body or otherwise declines to provide legal services to a governmental body, the governmental body shall be authorized to employ or contract with an attorney to provide legal services to the agency. And I would add, until the AG resume such representation. Would that be something you think advisable?
Yes, Madam Speaker, I think that would be a prudent, as long as the Attorney General's office, once we get past these questions with the courts, we would be able to resume, give notice and resume representation.
All right, and then if you are reviewing the $500,000 contracts, you're saying you're going to resume that, you're going to be able to approve them. What if you reject them and you let the agencies know? Is that going to be considered giving them legal advice, contrary to your decision not to advise them?
No, we'll have the disclosure in the documents.
All right. Right now, the government is authorized to hire at the Department of Administration a procurement council. I think we had one recently. I think that was what Bob Kono, the late Bob Kono, was serving in. But the statute allows that. And so I think for procurement, I can see that the agencies can be advised by the Procurement Council. Contracts above $500,000 still will be signed off. And if there are any other questions, then they have to hire their own lawyer or for a temporary period.
Madam Speaker, in terms of that, they already have their counsel. The council has, and in the past, called the AG's office for its perspective. Remember, just because a government official calls our office doesn't mean that we can't just say that, hey, we're giving you our perspective as the Attorney General representing the people of Guam. We don't have the attorney-client relationship, especially when the attorneys call us. So we can give our perspective as colleagues and so forth. So there is no need to increase their office size at the GSA for that purpose, because they can just simply call the AG's office, call Mr. Botha. And
they're already authorized.
Correct.
What about what about this whole part that we're talking about with GPA? They want us to waive that stay. And in the governor's bill suggested also is that we say where the AG has not acted within a period of time, 7 days, that the agencies themselves get to waive this stay.
I don't think that would be prudent if we want a check and balance in the system. I have Mr. Botha that can speak specifically to the GPA reference.
Please.
Yes, Madam Speaker. What's proposed in Bill 206-37 is two things. First, the waiver would be on the 90-day limitation contained in Section 5215E, and the waiver and the legislature would be specifically allowing the procurement to proceed forward for a 2-year period instead of the 90-day limitation contained in for regular emergency procurement. And then secondly, the stay of proceedings in the event of protest under Section 5425G1, what that provides is that in the event of a timely protest, the agency, Guam, shall not proceed forward with the solicitation of the award prior to final resolution of the protest, and any such action is void unless Chief Procurement Officer, in consultation with the head of the agency and the Attorney General, makes a written determination that the award of the contract without delay is necessary to protect the substantial interest of Guam. And so basically that section is being waived in terms of the, if there's any protest, there would be no procurement stay as there normally would under any normal procurement. But they're waiving it for the purposes of this temporary emergency power a contract that's being as the agency GPA has said that in the event of any protest that they would be unreasonably delayed, and so therefore they're asking the legislature to waive those procurement stay provisions.
All right, my time's up.
Madam Speaker, if you would like, I can yield you my time.
Sure, I would like
Okay.
that. Thank you. Do you think that it's necessary? What if other agencies ask the AG to, first of all, regarding GPA? So GPA said they're going to work with the Attorney General's office, that they are going to submit the documents to them, they're going to get their signature on them, but now I guess we're waiving the stay, so they don't need the Attorney General's approval of lifting that stay anymore. Is that correct?
That would be correct, Madam Speaker. The only assistance that was, AG Moreland had previously addressed is for a previous contract involving the GECO diesels. GPA had asked the Attorney General to indicate that, in order to not have a stay, that the Attorney General make a written determination that the award of the contract without delay is necessary to protect the potential interests of Guam. And the Attorney General determined that there was no basis to do so, and so of course that procurement stay was there, and then there was an appeal that was made to the Office of Public Auditor, and then in that particular case, the parties determined to dismiss the appeal.
All right, but so GPA in the bill that we're considering voting on later is that contract will still be submitted to the Attorney General. Is that your reading for its signature because it's over $500,000?
Yes, Madam Speaker, I think it's the provision on line 15 that basically says the Attorney General's approval as to the contract's form and legality in accordance with 5 GCA 5150 must be completed within 5 days of receipt of the procurement package from GPA. So I believe the legislature is still requiring that the Attorney General's office would review the contract.
There's, of course, been some letters back and forth with other companies suggesting that there's maybe an issue. I don't know, but I'm asking you, is there going to be a problem with this contract? I'm not sure if that's what you said this morning, Attorney General. Are we suggesting that there is an issue that you might not be able to sign off on the contract?
No, I don't believe so. That was a concern, just to raise it to the senators, your senators' membership, that there's a concern of a possible vendor. This goes towards, because you guys are receiving an emergency procurement that is already ready to award, and that's the situation, as opposed to asking people to submit.
All right. For other agencies, for contracts that have not yet been awarded, normal procurements over $500,000, the AG is supposed to sign off those contracts. They're also supposed to, for form and legality, and that the procurement process was followed, right? Are you going to be able to do that?
Yes, Madam Speaker. I think what you're referring to is that any contract for any agency that comes before the AG's office, other than this exception, the contract's ready for award, the AG's office would be involved from very beginning, and in fact, all phases of the contract, pre-bid, once they put out the notice of bid, and then a review of the vendors and all the rest of it would be followed. It's just that this bill, the process is truncated.
But are you going to be able to do that after having withdrawn from some of these agencies' representation?
Yes, we will.
All right, and then the GPA, we received a letter from their counsel to our council yesterday that was distributed on the floor somehow, where after GPA had assured us that the AG would review their contract, this letter from their counsel says that GPA is seeking a complete exception from the AG's review of the procurement. But is that what the bill does? I'm very concerned about GPA telling us one thing on one hand and then something else on the other hand. This is the core of the problem. I think that, why we're in here on an emergency session to deal with this, because we can't get the correct facts straightforward or representations from these people sometimes. And I think that's really the core of some of our bigger problems in the government. It's really just getting all the facts. So do you see that GPA will be able to be exempt from AG review of this procurement? Because that's what their lawyer says that they want.
Madam Speaker, they may be asking for yet another floor amendment to this bill, but as written, as I read it, certainly the bill is directing the Attorney General to review within 48 hours for approval as to the contract's form and legality in accordance with Section 5150. Which has not been changed. There's no proposal to change that currently before this body. So that is the law which requires the AG's approval, certainly as to the final contract at the end. Now, maybe GPA's counsel desires that the AG's office be entirely out of the picture, and that they not review the contract. That's certainly a possibility, Madam Speaker, but unless this bill is changed, we believe that that was addressed yesterday, that certainly this body expects the AG's office to complete the review within 5 days as to the contract's form and legality for this emergency power contract with Agreco International.
All right, thank you. So I'm thinking, and I'm not trying to affect anything that's going on over in the court or interfere unnecessarily between your representation of the executive branch, but I just want to make sure, again, my concern that's still left is the representation of agencies, right? So for example, we talked about how they would be able to hire lawyers. You're going to have to sign off on those contracts, and you have said in here you're going to do that so that they are not left unrepresented.
Yes.
So that might require us to allow this in a bill, some temporary nature.
Correct.
Also, that would apply, I think, to your representation of, for example, in statute of GSA, if there is a, in civil matters, it says the Procurement Council shall advise the Chief Procurement Officer on civil matters in which GSA is legally interested, provided that the Office of AG shall represent the GSA. So we have to make that as there as well.
I believe so.
And then, all right, and then that would resolve agencies, for example, Chamorro Land Trust, from moving on. All right, and then I guess that's it for my questions right now, Mr. Chair. Thank you.
Thank you, Madam Speaker.
Madam Speaker. Senator Taitigui, you're recognized.
Thank you, Mr. Chair, and thank you again for the Attorney General's office to being here, every one of you. Greatly appreciate it being on time. And I do apologize for it being so delayed. You know, earlier you mentioned something that everyone needs to realize, that your office is not just doing a good job, but you're answering the call of constituents who are whistleblowers. And definitely the Office of Attorney, the OPA's office on their concerns. I too have reached out, to you as well on concerns such as this, and you've done nothing but accommodate my request to research this. I mean, I'm one of those people, like, you join my club just because I ruffle some feathers or, kick up the dust, everyone's now going to attack me. As like was mentioned, they have things to protect. And it's very unfortunate, but I think you're doing an excellent job. And, and that's coming from a person who shows up for public hearings 95% of the time and session 95% of the time to review what's going on in the community and do what's in the best interest. And I too follow the money. And that's what brings me to the concern of the Bill 206 and the process that went down. So I guess I'm going to talk to Graham about this, Attorney Boa, because I know you worked as the attorney for GPA for many years. And I just trying to wrap myself around this, because this could have been done through non-emergency procurement. I'm pretty sure it could have done. But it just seems that there were some changes back and forth, and then I'm looking at the cost. Mr. Roa, do you know that the cost for this for 2 years annually is going to be $12 million a year for the... Is this just for the rental of these equipment?
Senator, yes, to my understanding, based on the documents that were filed with the PUC and the CCU, that it's approximately up to $12 million a year for 20 megawatts, and it would be for that 2-year proposed
so about
period of the
24,
contract.
right? $24 million it's going to cost. Does this include the operating cost of this generator, the fuel, the maintenance on it, and does that incorporate that cost?
Well, since these are temporary generators that are brought in, it's the same company that had done this in 2016. Generally, what they're responsible for is they're responsible for all the maintenance and operating of those units. The only thing that supplied generally is fuel or diesel fuel by GPA, pays for the diesel fuel and provides that to the company running the temporary generators.
And usually it's every 6 months that the LEAC is visited on fuel charges. Do you see that any other additional cost is going to be placed on our customers, GPA customers, moving forward with this high $25 million, rental of these generators?
That would be a question that's probably more appropriately addressed for GPA as to the...
But in your experience, being at GPA, knowing these certain types of contracts that are exorbitant in cost, it's one thing to tell us that, it's not using the verbiage temporary power generation capacity to stave off load shedding. If you look at the meaning under stave off, it doesn't say it's going to avoid any load shedding. It's just going to delay it for a period of time. That could be like, 1 month? And then we go into load shedding. So we know that's not going to correct it. But using that word stave, S-T-A-V, they have a clever way of using the word. But I'm sorry to regress on this, but I'm just seeing that this may cost consumers additional, fees for the customers for GPA. Do you see something like that could happen?
Well, Senator, to the extent that you use any smaller units, these are generally 1 megawatt units. Those are generally more expensive to run than the bigger units, such as the Cabris units or perhaps the combustion turbine units, the bigger, larger 20 megawatt or 50 megawatt units that are the Cabris units. It's generally long term. It's less expensive to use the larger units, but it would be, GPA would be able to give you the details as any potential increase in cost from running smaller generation units in this case.
And that's my biggest concern here. That's a red flag on the field. Definitely, if you had another option to lower the cost of power, and to just go out, let's go buy the most expensive. It kind of sounds like the Taj Mahal of a hospital that's trying to go forward too. But that's why I'm really weary about this. So the people of Guam who's listening, if you think that this is going to not increase your power bill because we're using one of the most expensive ways to generate this type of additional power, then just be prepared.
And Senator, I would, if I may, I would agree with you 100%, and it's going to be a hidden damage when people realize once the legislature stops that $100 credit, it's going to could potentially double it on the amount more money that's going to have to be spent if these units are. It's the same idea with the fast tracks when they brought them in decades ago. They were more expensive. They weren't using the low sulfur fuel oil, I think they call it, for the fuel. Diesel is expensive, more expensive to operate. So you are very correct in what you're saying.
So that's why I think that we could have avoided this emergency procurement and gone through a non-emergency procurement, be able to address the concern of going from 40 megawatt to 20 megawatt in the midst of a procurement. And was everybody notified? Was the other companies that were bidding for this notified? It's very concerning, this whole process, this whole 206 and how it's pushed through, more expensive. But can you explain how the change from 40 megawatt to 20 megawatt, can that actually be done in the midst of a procurement? And if it is, what's the process to notify the other bidders?
Well, I would say, Senator, in response to your question, it appears that I believe yesterday there was a letter provided by another vendor who did not appear to have bid on this contract, but indicated that they felt that there wasn't sufficient notice as any changes in either what was requested or the specifications for that. And so that is the type of thing that could result, in a protest, obviously, and obviously if the protest is waived, that won't go forward. But generally, if there are vendors that are out there you would put them on the vendors that do the same or similar type of work. You would put them on the list of those being notified of a potential procurement, emergency or otherwise, just so that you have as many vendors, you know, so that there's certainly adequate competition in this case. But we don't have all the details on that other than just the letter from the vendor, but we can certainly look into that and ask
Well, I
those
very much
questions.
hope so, because even though you're only supposed to look at the contract, the process in which it happened, and we'd like a full report on that. I'd also like to thank you again for being here today and doing everything. Stay the course. There's certain senators in here who are trying to sabotage the Attorney General's office, and that's no way to treat, because how they treat you is how they're treating the people of Guam. You're the protector of this island from individuals who've already lost the people's trust, continue to break laws. So I ask you to stay course, and there are much more senators here who support the Attorney General.
Thank you, Senator
And
Titlegy.
people on Guam who support you as well. So thank you so much.
Thank you, Senator Titlegy.
Senator Fisher, you're recognized.
Thank you very much, sir. Mr. Attorney General, I am not here to fawn over you. I am here to ensure, to the best of my ability, that the people of Guam are getting the service they are entitled to. I know that the agency is concerned about a particular issue. If they do not sign this waiver, will you still meet the 5 days you promised yesterday?
Are we talking about Guam Power Authority?
Yes.
Yes.
Okay.
We commit to that.
Okay, you've committed to that, and so just to allay any anxiety that the agency may have, they will not sign this waiver that you've created, yet you will meet the 5 days that you pledged.
That is correct.
Thank you, sir.
Thank you.
Now, I was listening to, sir, you, Mr. Parkinson, my friend Senator Parkinson, was asking you certain questions, and you declined to answer them, citing the existence of a case or cases in the Superior Court. Is that correct?
That's correct. Ongoing litigation.
Okay. And I appreciate the fact that you don't want to interfere with ongoing litigation, but my concern is if you don't want, obviously you don't want to do that. No attorney wants to interfere with ongoing litigation, yet you submitted a bill for our consideration that ultimately will eviscerate any decision that Judge Manabusan or whoever the judge is over there who's got the Areola case. You know very well there's a motion on there to disqualify you, yet you submitted a bill that would essentially render a court's decision meaningless. Is that correct?
Not necessarily.
Explain, please.
It's meant to clarify what we believe already exists in Guam law and avoid any further problems dealing with these procurement type of issues. It's to point out what we believe is already Guam law, that the AG's office does not represent a government official. The AG's office, like I've said before, represents the government of Guam, and these government officials are stewards and fiduciaries of the people of Guam, the government of Guam.
Well, without question, sir, that bill would interfere with the functioning of the Superior Court. There's no quibble to that. I would suggest that you rethink your approach there.
Well, Senator, I've already indicated.
I have a question for Mr. Botha. Sir, I was concerned, it's not the substance of the email you sent, but you sent an email to your client, GPA, and in the attorney-client context, you then revealed the communication to Fred Harecki, to Senator Terlahi, and others, and there might be a blind CCC. Sir, by breaching the attorney-client duty, do you believe you have committed an ethical violation?
I'm going to step in there, Senator Fisher.
Sir, the question is to Mr. Botha.
Senator Fisher, the client is the government of Guam. The legislature is the embodiment of the government of Guam.
I understand that you are defending your position. The question is to Mr. Botha, and this is a personal question to him.
Well, not necessarily.
It is a personal question to him.
He
has an obligation, Mr. Attorney General. The question to Mr. Botha is, do you or do you not think that you have committed an ethical violation by breaching the attorney-client privilege?
Senator Fisher, I believe that in providing advice to the client, which is the agency, I've certainly advised them the consequences of what they have done with their actions here and what they've tried to do in the emergency procurement.
All right, but the question, sir, is you circulated this beyond your communication with the client, an absolute breach of the attorney-client relationship.
The client is the people of Guam.
Do you believe that you, sir, have personally committed an ethical violation?
The client is the people of Guam.
Earlier, a senator, well, a friend of mine, insinuated that a difference in political views might constitute evidence of corrupt motive here on the floor. That was my friend, Senator Brown. I see no evidence of any corrupt motive by any of my brothers or sisters here on the floor. I reject, absolutely, that statement, and I reject the insinuation, and I would do so on behalf of the dignity of this body. You, sir, Mr. Attorney General, admonished us or advised us to follow the money. Do you have any evidence that the Guam Power Authority is corrupt?
Sir, I will not speak to ongoing criminal or civil investigations.
But you will insinuate it when they can't defend themselves. You will insinuate that these people are crooks, yet they can't come in and defend themselves.
What exactly did I insinuate, sir?
Follow the money.
Well, that's the motto, that's the mandate of every criminal or civil investigation, follow the money.
Mm-hmm. Do you have any, and you did that in relationship with the Guam Power Authority, do you have any evidence of corruption by those individuals? And if you do not, will you withdraw that insinuation that hurts people personally when they cannot defend themselves? Sir, we must, none of us, act as bullies.
You have mischaracterized my testimony,
Sir,
Senator Fisher.
I do not believe I have. If you insinuate...
You definitely have.
If you insinuate a bad motive, you must be able to back it up. Otherwise, you're hiding behind a microphone.
You're mischaracterizing my testimony, sir.
Okay, thank you. Just a little bit of information that would be to your benefit, Mr. Attorney General. I was at the Attorney General's office beginning in 1996. We had a conflict wall. We had a white-collar crime division, and that white-collar crime division was actually behind 2 locked doors. It worked very well. I just wanted you to know that when you became in your first round as Attorney General, you were by no means, breaking the ice here. Government of Guam has been investigating white-collar crime and corruption within the agencies, if it exists, for years and years and years.
Among the elected Attorney Generals.
You had also stated that the position... Yes, sir.
Senator Cadata, I'm guessing you want to yield your time to Senator Fisher?
Yes, thank you for that motion.
Thank you.
Thank you so much. The bill 206, which is under consideration, I hope the entire island of Guam can read it. It's posted on the internet. In no way does it create 3 attorney generals.
It does.
No, it doesn't.
Yes, it does.
No, it doesn't. No, it doesn't.
Okay,
yes,
well,
it does.
no,
it doesn't. Yes, it does. Okay, it in no way does that. That is an absolute mischaracterization. Criminal matters will remain, including white collar, will remain with an elected territorial prosecutor at some point, and matters of which your solicitor's division normally carries out will be attached to the governor's office. So it's important not to overstate what the bill does, and it's important not to understate it.
I can show you where the 3 attorney generals are in it.
Yeah.
Section 36102 in Bill 25737 talks about creating the public prosecutor. That has the attorney general's authority. Then you have a civil attorney general that's been the appointed or the elected one, and that's in section 3 of the bill.
Absolutely.
Then you have a final one.
No argument.
Which is the final section 8, appointment of special prosecutor. You've created 3 attorney generals, and the governor is the one in charge of the appointment of special prosecutor.
Okay, sir, I've already made the observation that when you spoke about the Guam International Airport Authority. You made a reference to them, the Guam Power Authority, Port Authority of Guam. You insinuated, again, sir, you insinuated that there is crookedness, criminality taking place at these vital agencies. Yet again, sir, you don't provide any evidence and you hide behind a shield saying, I won't talk about an ongoing investigation. Fair enough. But if you're not going to talk about the ongoing investigation, don't mention it.
Senator Fisher, look at my letter dated...
These people cannot fight back.
Senator, February 28th letter, attachment 1. It contains the OPA reports of these different government departments and agencies. Then the attachment 2 identifies and summarizes the 22 government departments and agencies.
I know that, sir. My observation
It's not just us.
My observation is simply this. You are the Attorney General of Guam, and you are damaging reputations where people cannot fight back. I urge caution. You have a special responsibility. Finally, sir, well, I think you would agree that the Organic Act clearly allows for an appointed AG by the governor, whoever that's going to be.
That's correct.
And a territorial prosecutor, correct?
That's correct.
All right. Sir, again today and yesterday, you were emphatic that the law doesn't allow you to create a wall, a conflict screen, correct?
Emphatic. I pointed out that the statute does not require it. Yes.
Well, I'm just going to tell you, I've got the clip right here. Do you want to hear it?
Well, I said that, you used the word emphatic. I said that I did say it by pointing out the statute, the statutory scheme. Okay. I agree with your comment. Well, the characterization, though, is a little bit off.
Well, I appreciate, sir, but you said you couldn't you said you could not create the conflict screen.
I didn't say I couldn't create it. I said that it
no, sir,
was not required by the statute.
No, sir, you actually said you couldn't do it. I've got the video, or I've got the videotape.
Well, I disagree. And if anything, I will make it clear to you that we can create conflict walls, but that is not what the statute requires. You will take away the elected Attorney General's control of that office over 1/2 of the work.
Yes, sir.
That is what
yes,
to
sir.
clarify any ambiguity we have.
Yeah, you did need to clarify that because on October 30th of this year, you told the Superior Court that there is a conflicts wall, and you said in a memo on April 17th that you could and must create a conflict wall, while yesterday, sir, you said you couldn't do it. I submit, Mr. Attorney General, that you were misleading the body.
No, this is a developing legal issue.
Sir, I have no further questions.
May I finish, Senator Fisher? Or do you want to cut me off like that? That's unfair. Thank you. Senator Fisher, this is, as I said, this is a developing legal issue, hence it being in court and argued. Before Judge Terlahi, I did the oral argument and specifically said to the judge that it's against the statutory scheme, that the Attorney General should not have to create the conflict walls, but this is that abundance of caution that I protect my attorneys and my team with. We create conflict walls in the ambiguity, but in our arguments, we do not believe that it's necessary.
So well, you may not believe so, sir, but create the conflict wall so we don't have to come in here on this drill.
No, I will not. I will not, sir.
You can fix the problem. You have created the emergency.
No.
You, sir, have created the emergency. You can create a conflict wall just like the Department of Justice, just like the other 52 territories, and just like you did.
I will not abandon the people of Guam's mandate that I provide the public prosecution and also direct the government departments. You are cutting the Attorney General's office into two divisions, two Attorney General's offices when you do that. Well, where in the statute does it allow for that?
Well, Mr. Attorney General, that certainly is a paradox. You said you cannot abandon your duty to the people, yet essentially 22 or more agencies have been shut down. How is that not abandoning your duty to the people?
To make sure that we're in compliance with a potential reading of the ethics walls, the ethical requirements, that's what we did. That's the whole problem. It's a temporary, and Senator Fisher, you are an attorney. Where in our rules of professional conduct does it distinguish the Attorney General's office in reconciliation with Chapter 30? The Attorney General's duties aren't mentioned.
Sir, just read organization as client. I have no further questions.
The organization's client does not apply here for the Attorney General.
Thank you, Senator Fisher. Senator San Nicolas?
Nothing, Mr. Chairman. Thank you very much. Thank you, panel, for being here.
Sudos Masi. Senator Perez?
I yield my time to the speaker if she has any further questions. Thank you.
Okay. Senator Shelton?
Thank you very much, Mr. Chair, and thank you, Attorney General and team, for being here this morning. Attorney General, can you tell us how long it typically requires you and your team to complete a review of procurement contracts? What is your average?
I'll let Mr. Botha speak to that. I know the mandate came down that we want it reviewed within, or I want it reviewed within 30 days. If there's an emergency situation, which we have every week, I ask them to expedite certain contracts that are time sensitive. So yes, and Mr. Botha, if you allow him to also address that directly, thank you.
Yes, please, thank you.
Thank you, Senator. It basically depends on whether the agency provides all the documentation up front. What happens sometimes in the review, even for the pre-bid process, is that they're missing certain determinations, they're missing certainly parts of the procurement file. So if they get those back to us right away, then we can proceed forward and accomplish it within the 30-day period. Unfortunately, what sometimes happens is due to maybe the workload for those agencies at their procurement division, you know, and then those could be the ones that don't have an attorney. What happens is it takes them a while to get back, or the determinations that weren't done in advance, they've got to do those, right? But we work with them. I mean, what we've done, you know, for some of the agencies that have asked for an expedited request, like Guam Memorial Hospital, they had an NGO suite, you know, that they had money to spend or whatever. We worked directly, you know, with the former attorney there, Mr. Jeremiah Luther, you know, to work with them to say, hey, get your client to sign these things, move them forward, and then we got the contract approved. And my understanding is that, you know, they've you know, ordered the equipment and it's just awaiting installation and everything. So it kind of depends on not necessarily the workload of the AG's office, but if the agency is able to give everything up front, then we can certainly work to accommodate that in a 30-day period. But a lot of times the agencies just because they may be short-staffed on the procurement side, they're just not able to provide all the materials needed for a proper review.
So in a perfect scenario, it is always reviewed and signed within 30 days, if all documents are provided?
Yes, but that's generally not the case, because there's always, you know, something missing from the file, and so we try and help out the agencies to assist them and you know, get those documents to us.
Okay, thank you. And so with regards to the adult daycare contract and other public health contracts for our Manamku, what is the status of those contracts and those reviews at this time?
So, Senator, with regard to the adult daycare, my understanding is that's been approved. That is a contract with HSP, Gurusami Inc., and so that with public health has been approved, and I think it's just waiting for them to pick it up.
Okay, thank you very much. And with respect to discussions yesterday on the designation of Special Assistant Attorneys General, can you clarify the official policy of your office, Attorney General, on the appointment of non-AG lawyers to assist Gov Guam with certain cases, and what has been done in the past for matters involving CLTC and Guam's political status plebiscite?
Okay. Senator Shelton, good morning. Are we speaking of specifically within the AG's office in that line of questioning?
Yes.
The Supreme Court of Guam, since I believe the promulgation orders since 2022, have recognized that there are not enough lawyers on Guam. So when I was elected as the AG, we needed to provide enough lawyers so that we can provide, to do the duties for our people. What we did was we started to designate and appoint special assistant. We basically contracted out under the Attorney General's office attorneys. So those attorneys have been getting us past this recruiting phase that we've been doing. So that's what we've done on that. The SAGs, we withdrew all of them that the other AG had appointed. those were private law firms that he had appointed to take care of agencies for the procurement. I think it was primarily for the procurement of the 500,000 and above. So we internalized it, and they're all going through our civil division, Mr. Botha. So that's how we've done that. The preference is always to have salaried attorneys that are working only for the people of Guam. But the AGs for decades, even the appointed era that Mr. Fisher was pointing about before 2003, they've always had contracts with private law firms in order to do either conflicts counsel or to do special prosecutions. That's my recollection and observation of our operations as an AG's office. But for me, it's better to hire an attorney because the salaries are not an hourly rate type thing.
Okay. And Mr. Attorney General, you commented at the beginning of your presentation yesterday afternoon to the effect that the process has been established to allow your office to continue reviewing procurement contracts and other agencies' requests, and that no further action or new legislation is needed. So do you maintain that position today? And if this is the case, should we conclude this conversation?
I agree with what you're saying. I do point out that Madam Speaker had a good recommendation based on the governor's bill. And, I would like to make this clear from my perspective as an elected official. I want to continue working with the governor. Everybody, as Mr. Fisher pointed out, Senator Fisher, Attorney Fisher pointed out, everybody is innocent until proven guilty. This is just the investigation struggles that we're dealing with, fulfilling the role as the public prosecutor. So with that being said, Madam Speaker's recommendation during this temporary period that I can sign off on their retaining private counsel to give them legal advice, I would recommend that.
Okay, thank you very much, and I appreciate your sentiment to continue working together, I think across all branches of the government, so that we can continue these vital services. I don't think anyone wants to be put into a state of fear for us to worry our manamku or anyone in any other department to think that they cannot continue their work. And so I hope that we're able to move forward from this moment and work together.
Thank you. Thank you,
I
Senator
appreciate
Shelton.
that. Thank you very much, and thank you, Mr. Chair. At this
Senator
time,
Swanson.
I'd like to move for us to recess until 2:30 today.
On the motion to recess until
And
2:30?
I will give some clarification on my motion. I'm asking for 2:30 because there is a scheduled public hearing that we will need to open to recess and then come back into our session here.
Senator Swansea, Senator Shelton, on the motion to recess until 2:30 promptly, is there any objection? Seeing none, motion passes. See you at 2:30.